Hello and welcome to JEG Law. Today we're going to talk about the recent executive action put into place by President Obama. President Obama's executive action involves deferred action and advanced parole so as to open up access to adjustment of status to hundreds of thousands, if not millions, of people who were otherwise unable to benefit. The highlight of our president's recent executive action was to expand the availability of deferred action in two ways. First, parents of U.S. citizens or permanent residents may be granted deferred action with parental accountability, otherwise known as DAPA, if they meet the following criteria. They must have lived in the United States since January 1, 2010. They must have been present in the United States on November 20th, 2014 and afterwards. They must have passed a criminal background check, and they must have been in unlawful immigration status on January 20th, 2014. DAPA provides both 3 years of employment authorization and permission to travel outside the United States by means of advanced parole. Second, President Obama's order also extended deferred action for childhood arrivals, DACA, with employment authorization to 3 instead of 2 years. As before, DACA would be available to persons who graduated high school or who earned a GED or are in the process of doing so and who entered the United States before reaching 16 years of age, with additional generous changes. They have lived in the United States continually since at least January 1, 2010, rather than the prior requirement of June 15, 2007. They are of any age, and this removes the requirement to have been born prior to June 15, 1981. They have passed a criminal background check, and they have been in unlawful immigration status as of November 20th, 2014. As explained further, by providing advanced parole, DAPA and DACA benefits persons who previously entered the United States without inspection and who, without parole, could not immigrate within the United States as parents of adult U.S. citizens or spouses of U.S. citizens. Prior to the creation of DAPA and DACA, spouses of U.S. citizens or parents of adult U.S. citizens who had entered the United States without inspection would have to consular process after being petitioned by their U.S. citizen relative. This is because immigrant processing within the United States, known as adjustment of status, is unavailable after illegal entry. Yet with consular processing comes the need to waive prior unlawful presence, requiring that extreme hardship be proven to befall the U.S. citizen or permanent resident spouses or parents should an intending immigrant be deported. Processing unlawful presence waivers has generally grown increasingly difficult and risky. Moreover, parents of adult U.S. citizen sons or daughters, after entry without inspection, are unable to immigrate through the petition of their adult offspring if they lacked a U.S. citizen or permanent resident spouse or parent, making hardship waivers unavailable for them. By making available advanced parole, DAPA and DACA remove barriers to adjustment of status and eliminate the need for consular waivers. Advanced parole allows someone to depart from and return to the United States to be permitted entry at an airport, seaport, or roadside inspection station. Under President Obama's directives, departure and return with advanced parole will legally place someone in the same position as if he or she never departed at all. By treating advanced parole as a physical departure, but not a departure under the law, two impediments are removed which otherwise prevent immigrant processing within the United States. First, a fundamental requirement for adjustment of status is that a foreign-born person be inspected at a port of entry and either admitted or paroled by an immigration officer. The person who departs from and returns to the United States using advanced parole can adjust status through a qualifying relationship after returning to the United States. Second, by treating international travel with advanced parole as a physical departure, but legally as somebody who never left the United States, the need for an unlawful presence waiver is eliminated with all of its risk. To remove some of the mystery from the President's executive action, I'll explain both the difference between admission and parole and how recent changes in immigration law have revised parole so as to eliminate the need for a waiver. Admission allows someone to enter the United States with either immigrant or non-immigrant status. Congress legislatively creates many immigrant and non-immigrant classifications defined within federal statutes to govern immigration law. However, the President cannot make law. He can only order how the law is enforced. It has long been established that an immigration officer under the federal executive branch may parole a foreign-born person to enter the United States who cannot qualify for admission with immigrant or non-immigrant status. Thus, the President, being the chief executive officer, can direct immigration officers to liberally parole persons into the United States after being granted deferred action so that they can adjust status through a qualifying relationship created by Congress. Finally, in holding that parole is not legal departure, President Obama's directive is neither novel nor new. In 2013, the Board of Immigration Appeals, which provides case decisions to guide both immigration courts and the U.S. Citizenship and Immigration Service, held that departure from the United States with advanced parole, when accompanied by an expectation to immigrate as an immediate family member of a U.S. citizen, is a physical departure but not a departure under law. President Obama's objective to broaden the application of this principle to parole issued under DAPA and DACA similarly enables family members to immigrate without the risk attached to consular waivers. This is wonderful news for many immediate family members of U.S. citizens who no longer must worry about securing legal status for their loved ones.